Yes, sir. Next.
Under the heading for orders on petition serial number 11, Saroz Devi versus the State of Bihar for the appellant Sri Raju Giri.
Lordship had earlier heard this matter, and void order dated 23/8/2022, Your Lordship, had condoned the delay. Lordship, the question is whether the temporary employee, are eligible for pension or not, Your Lordship. Over here, there is a widow before Your Lordship. She is praying for her family pension.
Which is the relevant rules?
Now, Lordship, one judgment I had given Your Lordship.
Not judgment, rules.
Rules, Lordship, may kindly say relevant for the purpose would be Rule 58 and 59, Your Lordship.
Sir, the
Rule 2.
Deceased employee was working with whom?
Deceased employee was working the jail administration, Your Lordship. As jail administration, Your Lordship.
What administration?
Jail, Your Lordship.
Jail.
As a warden, Your Lordship. Anudeshak.
So the employees of jail, regular employees of the jail, Lordship, are governed by Bihar pension
rules, Your Lordship.
Now you have to point out only from Bihar pension rules that you are entitled to.
Lordship. Now, Lordship, may kindly see Rule 58 and 59 of the rules, Your Lordship.
Rule
58 and 59. Now, Lordship, Rule 58 is in regard to the government employee who are permanent, Your Lordship. The first is the service must be under government. The employment must be substantive and permanent. The service must be paid by government. These three conditions are fully explained in the following subsections. Now, 59 is the exception, Your Lordship. The provincial government may, however, in the case of service paid from general revenues, even though either or both the conditions...
Which rule you are reading?
Rule 59, Your Lordship, of the Bihar pension rules. 1950. It is at page 12, Your Lordship, probably in my Lordship. Now, Lordship, Rule 58 is in regard to the permanent employee, and 59 is the exception, Your Lordship. Over there is a circular, Your Lordship, regarding Your Lordship on the next page.
Read Rule 59.
Lordship.
How it is applicable
Lordship. The provincial government may, however, in the case of service paid from general revenues, even though either or both the conditions 1 and 2 are not fulfilled, declare that any specified kind of service rendered in a non-gazetted capacity shall qualify for pension. In individual cases and subject to such conditions as it may think fit to impose in each case, direct that service rendered by a government servant shall count for pension. Now, Lordship, in the year 1969, there was a...
You are not a government servant? Lordship, you are not a government
exactly,
servant?
Lordship. I am a temporary employee, Your Lordship.
So you do not fall under the definition
Lordship,
of
may
government servant?
submit, Lordship. Lordship, there is a circular of 12/8/69, Your Lordship.
So what is the date of circular?
12/8/69.
12/8/69.
If Lordship would permit me, I can place it. I can read it, Your Lordship.
Read.
Declaration of temporary service of a government servant who is not confirmed as pensionable. Under the existing pension rules, a temporary government servant is not confirmed in any post, is not entitled to pension unless his services are declared pensionable under Rule 59 of the Bihar pension rules. There are a large number of temporary government servants employed under different schemes which are in existence for the last 15 to 20 years, and it will cause hardship to them if they are not allowed pension after the retirement. The state government, after careful consideration, have therefore been pleased to decide that if the service of the temporary or officiating government servant who is not confirmed in any post is continuous and is more than 15 years, it will be considered as pensionable under Rule 59 of the Bihar pension rule. These orders will be applicable to government servants retiring on or after 12th August 1969. Now, over here, Your Lordship, this 15 years has been scaled down to 10 years by subsequent notification, Your Lordship. That has got mentioned in the division bench order, which I had already passed on to Your Lordship, on the earlier occasion. There is a finance department notification, Your Lordship, circular.
Sir, will it prevail over the rules?
Lordship, there is a full bench
decision. Correct, circular.
What I am submitting, Lordship, there is a full bench decision of this court on this issue, Your Lordship, in regard to worst charge employees, Your Lordship. That is, Your Lordship, 2019, Volume 1, PLGR.
2019?
Volume 1, PLGR. Page 1015.
Volume 1?
PLGR, Your Lordship. Patna Law Journal Report, Your Lordship. Page is 1015. 1015. The relevant para is 7, 8, 9 and 70, Your Lordship.
Over the 7, 8,
9, wherein the work charge employment.
7, 8, 9 and
70, your lordship.
70. Okay.
70.
Yes.
And over there also the exceptions was taken ahead of your lordship of rule 59. And because worst charge employees, your lordship, they are from that, the worst charge employee, your lordship, this temporary employee.
If that judgment is contrary to law?
Pardon, lordship?
If the judgment, full bench decision,
Lordship.
is contrary to law, have they taken note of rule 50,
They have,
56?
they have taken note of rule 58,
No,
59,
56.
59 and 61. These three rules have been taken note of, your lordship. The exceptions under rule 59 has been taken note of, your lordship. Even the division bench has taken note of. Over here, the state, the same state was there, your lordship. Mr. P.K. Verma, the senior advocate over there also is there, assisting the court. Over there, your lordship, since the matter, they did not disputed that the temporary employee has not this thing, your lordship, pensionable, your lordship. The only dispute was that since they were adjusted in a non-pensionable service over there, your lordship, division bench order which I have already passed on, your lordship. So they were agitating that no, they are not entitled on pro rata pension, for pro rata pension, your lordship. Over here, in regard to the work charge employee, your lordship, only when the work is there, they are being employed, your lordship. In that case also, the court held that if they have worked continuously for 10 years, they are pensionable, your lordship. Kindly see para 70 of the judgment, your lordship, full bench. And over here also reference is of rule 58, 59 and 60, your lordship. The circular of the government also I have shown to your lordship.
Why this delay of 4 years?
Pardon, lordship?
Why this delay of 4 years?
No, delay can be condoned.
Pardon, lordship, the delay has been condoned probably, lordship. It has been condoned. I am sorry, lordship, I could not this thing submit before your lordship. On the last occasion, the matter was...
Circular will not prevail over the rules. Statutory rule will...
Lordship, within the rules itself, your lordship, because the government has the power to carve out exception, your lordship, in regard to
as long as rule is not amended, you are not entitled.
Lordship, the power is there under rule 59
Correct,
to carve out the exception.
Power is required to be exercised in amending the rule, not by issuing circular.
Lordship, the power itself is there to carve out the exception, your lordship. They can come out with the exception,
no,
and they have come out with the exception.
But in the form of rule.
Pardon, lordship.
But in the form
what I am submitting, lordship, may kindly see rule 59. If lordship would permit, I can again place it, your lordship.
Yes, sir.
Yes. The provincial government may, however, in the case of service paid from general revenues, over here also this payment was from general revenues, your lordship, even though either or both the conditions 1 and 2 are not fulfilled, declared that any specified kind of service rendered in a non-gazetted capacity shall qualify for pension. Over here it's any specified kind of service rendered, your lordship. They have the power, your lordship. Rendered in a non-gazetted capacity shall qualify for pension. Second one, in individual cases, that is of individual cases. I am in regard to the one, your lordship. So the government has the power to carve out exception, your lordship. And in regard to the temporary employee, there is a circular, your lordship, of 12/8/69, which has been applicable to each and every one, your lordship.
You have read that?
Pardon, lordship?
You have already read that?
Yes, I have already read, your lordship.
Why you want to repeat?
No, with lordship permission, I was reading it, your lordship. When lordship
No,
gave me permission,
why you want to repeat the same thing?
Lordship. So my submission is, lordship, that rule 58, 59 and 61 was taken note of by the full bench of this court.
Yes, sir.
And in paragraph 70 of the full bench decision, your lordship, in regard to the work charge employee, your lordship, which is not better than the temporary employee, your lordship. Over there it has been held that if they have continued for 10 years, your lordship, which is the qualifying period for pro rata pension, your lordship, they are pensionable and the family would also be getting the family pension. Over here also, your lordship, under Right to Information Act, to this lady, your lordship, they have informed that her husband worked from 84 to 95 continuously as worked from 1984 to 1995 for 11 years continuously, your lordship. And the qualifying service for pension has been there, your lordship. And therefore, I am praying, your lordship, that in terms of rule 59...
You can't say that qualifying service.
As far as
as long as your service is not regularized, you can't fit into rule 56.
Lordship, that's why I was referring to this government circular, your lordship.
All right,
of
sir,
69.
how many times you want to repeat?
That's
yes,
my
what
submission.
Do you say, Mr. State?
That's my submission, your lordship.
What do you say? What is
Lordship,
your stand?
the petitioner husband, he was not in a substantial post, lordship.
Huh?
Petitioner husband was not in a substantial post, and that's why he's not entitled for
then
the...
how do you overcome full bench decision?
full bench decision is for the work charges employee lordship. That is different. That is on the based of the work charge employees lordship. That is a different thing. Here he is in the he was not temporarily he was worked.
What is the difference between temporary and work charge establishment?
Work charge employees lordship for the time being they were
he is
they were
better
employed.
footing, better than work charge employee.
I see Lord. I take seek instruction on that point, Lordship.
So you want adjournment? What type of assistance you people are giving?
Because Lordship,
Sir, last time itself it was made clear that
it is contrary to the Rule 58 of the Bihar Pension Rules, Lordship. When he was not on the substantial
Alright,
post.
sir, how do you overcome full bench decision?
I will examine Lordship whether his.
How many years you want?
Only one day, Lordship.
Will hold as long as rule is not amended, it cannot be taken into consideration. And Supreme Court decision of the court that whatever the rules existing and particular date is required to be followed. No, they should amend the rule.
Full sympathy for your client.
Pardon, Lordship.
Full sympathy for your client.
Lordship, I am obliged, Lordship.
Bound by the rules.
I am obliged, Lordship.
1969 circular is still not incorporated in the pension rules.
ये तो कुछ लेकिन इसका रिकॉर्ड पे नहीं है कि कोई अवेलेबल पे नहीं पंचानवे में की गई थी आदत खराब हो गया हम लोग अस्थायी मुद्दा के पद पर अस्थायी पद पर किया गया था
Please take your seat.
Lordship.
Yes, take down. The appellant has questioned the, has assailed the order of the land single judge dated 18/7/2014, passed in CWGC 20341 of 2013. The appellant Saroj Devi is wife of late Anil Kumar Sinha, who was deceased employee, was appointed in the year 1984 and continued in service till the year 1995. Full stop. On account of his death, whether the appellant Saroji Devi is entitled to family pension, arrears of pension and family pension or not. Full stop. Deceased employee was working in the which department?
Working in jail.
Working in
Lordship.
Which jail?
Working in
Gaya
the,
Central Jail, Your Lordship. Gaya Central Jail.
working in the prison department. Full stop. The prison department, employees of the prison department are government servant, and such of those government servants who have attained the age of superannuation and retired from service, they are governed by rules called Bihar pension rules. Full stop. Rule 61 stipulates that service does not qualify unless the government servant holds substantively a post on a permanent establishment. Full stop. Undisputedly, appellant's husband was not holder of a substantial post and had a status of government servant in the department of prison. Full stop. That apart, rule it is necessary to reproduce the following rules. Rule 29, 30, 31. And under chapter 4 relating to service qualifying for pension dash rule 58, 59, 56 to 59. 56 to rule 60. Full stop. Reading of the aforesaid provision, it is crystal clear that the petitioner, deceased deceased Anil Kumar Sinha has no status of a holder of the substantial post read with the government servant. The aforesaid ingredient is mandatory for the purpose of extending pension and family pension under the Bihar pension rules, 1950. Next paragraph. On the other hand, learned counsel for the appellant Saroji Devi vehemently contended that even though deceased Anil Kumar Sinha has not stepped into the shoe of a government servant, or he was holding a substantial post, at the same time he is entitled to pension, and appellant is entitled to family pension in terms of circular wide memo number EN 1024/69/11779 F dated 12/8/1969 that temporary government servant, even though if he is not confirmed such a person is entitled to pension and family pension, and his legal heir is entitled to family pension under the Bihar pension rules, 1950. Further, he relied on a reported decision, namely so and so 2019 volume 1 PLJR 1015 within bracket para 7, 8, 9 and 70. Next paragraph. Learned counsel for the respondent state resisted the aforesaid contention and submitted that as long as deceased employee has not stepped into the shoe of government servant while holding a substantial post in a department, in such an event temporary employee is not entitled to pension, even though if he has rendered more than 10 years of service. It is submitted that it is a mandatory requirement that one must be government servant and he should have he or she should have held a substantial post, working against a substantial post. The cited decision has not appreciated the provisions of Bihar pension rules, 1950, in particularly service qualifying for pension. It is also submitted that circular/memo dated 12/8/1969 do not assist the appellant as long as the relevant provision under chapter 4 of the Bihar pension rules 1950 is amended appropriately. The aforesaid order do not override the statutory rules. To heard the land councils for their respective parties. Core issue involved in the present appeal is whether the deceased employee Anil Kumar Sinha and his wife dash appellant are entitled to pension and family pension or not. Undisputed facts are that deceased Anil Kumar Sinha has joined service in the prison department on temporary basis in the year 1984 without regularization of his service. He continued up to the year 1995. Thereafter he died. Next, for the purpose of claiming pension and family pension, deceased employee is deceased employee is required to fulfill the service qualifying pension under chapter 4 of the Bihar Pension Rules 1950 with reference to cited rule 56 to 60. Read with the rule 29, 30 and 31. Deceased Anil Kumar Sinha do not fulfill the aforesaid criteria for the purpose of extending pension and further family pension to appellant. Next, the appellant counsel relied on memo dated 12/8/1969 and cited decisions supra do not assist this of the appellant for the reasons that memo dated 12/8/1969 cannot override statutory rules made under Article 309 of the Constitution. The same has not been appreciated by the the same would be a hurdle for the purpose of extending relief sought by the appellant to stop. Next paragraph. The cited decision do not assist the appellant for the reasons that Apex Court in the case of Nair Service Society versus Bir Mastan reported in so and so para 48. It is held as under. The principle laid down by the Apex Court in the aforesaid decision is that relevant statutory rules is required to be taken into consideration before examining any judicial pronouncement. In the present case, reading of the aforesaid provisions of law under the Bihar Pension Rules 1950, the deceased Anil Kumar Sinha has not fulfilled the criteria of stepping into the shoe of a government servant, and he was not holder of a substantial post. Further, as long as rule under chapter 4 is not amended insofar as criteria that one must be a government servant and he must be holder of a substantial post to that of temporary employee and holder of temporary post. Also, the the appellants are not entitled with a tag of temporary employee and holder of a temporary post. Accordingly, the appellant has not made out a case, hence appeal stand dismissed.